presented before us. Honorable members, we would have a way forward announcement and closure, and then committee consideration on the revised APP for 2026-2027. So when we get to this item of committee consideration, we would then release Home Affairs and our presenters today with regards to their inputs. So that it is for today. Now I'm on opening and welcome. We note with concern that several politicians have been killed over the weekend during the local government registration weekend. And we are deeply concerned by this and express our condolences to the families and political parties. On issues of oral submissions, in our last meeting, we received the presentation from the content advisor on written submissions on the one-stop border post bill. We welcome the organizations and individuals who are with us today, who have made written submissions and will today do their oral presentation to the committee. The committee received 6 written submissions from individuals and 2 from organizations, noting that the following commenters will make oral presentations in our meeting today. Joint submissions, the Scalabri Center and the Catholic Parliamentary Liaison Officer, Agri SA, Bekane, Tabete, and Anele Sekau, and Tsepo Palazzi. We welcome these commentators to our meeting today and looking forward to hearing their oral submission on the bill. So as I said, members, I officially declare this meeting opened. And now I would want to ask Gershwin to give us apologies as submitted.
Good morning again, once again, Chairperson, members and department officials and our presenters present. Chairperson, we received 2 apologies from Minister Schreiber and Deputy Minister Nzuza, Chairperson. They are Deputy Minister Nzuza is on study leave at the moment, and Minister Schreiber has another meeting at the same time, Chairperson. Thank you.
Thank you, Gershwin. And please note, honorable members, that in terms of the Home Affairs Department, we do have a representative who would be actually leading the delegation, Advocate Erasmus. So there are apologies that have been submitted before us, honorable members. I would now note hence for the apologies and as well the adoption of the agenda. But again, members, I would want to alert you that I'm at an engagement bilaterals with EU here at Tash Hotel. So as soon as I finish with the apologies, I would be handing over to Honorable Nonkonyane for the procession of the meeting. I'm now noting hands for members for adoption of the agenda and apologies. Honorable Mukaye and Honorable Nonkonyane.
Good morning, Honorable Chair. Good morning to the Honorable members on the platform. Good morning also to the stakeholders, our officials, Chair. With your permission, I'm at the Acacia Park, and you know the network here is a bit of a problem. If you can just allow me not to switch the video on.
You are permitted, Chairperson.
Thank you very much, Honorable Chair. Chair, I'll move for the adoption of our agenda and also noting the apologies that have been submitted and your apology from your good self. We note you and we wish you strength for your further engagements. We know that you represent us well in those forums where we are not part of. Thank you very much, Chair.
Thank you, Honorable Mukai, for that strength I so needed for today. Thank you. Honorable Nonkonyane.
Chairperson, honorable members, distinguished guest officials, good morning all. Thank you, Chair. I rise to second Honorable Mukai's proposal. Thank you.
All right. Thank you, Honorable Nonkonyane. And honorable members, the agenda and the apologies have been duly adopted. So now, honorable member, I want to hand over to Honorable Nonkonyane for the whole session of the meeting. Honorable members, can you flight the agenda, please?
Thank you, Chair, honorable members, and distinguished guests. Thank you for giving me this opportunity. Without any further ado, honorable members, may I give the platform to the first speaker on our agenda, who is representing the Scalabrini Center of Cape Town and Catholic Parliamentary Liaison Officer, Mr. James Chapman. Mr. Chapman, the 10 minutes slot starts now.
Thank you very much. It's appreciated. Greetings to everyone. And I stand by the protocol or protocols observed. May I share my screen?
Pleasure, yes. Thank you.
Regrettably, it says the host has disabled participant screen sharing. I'm not sure whether perhaps I may ask for permission.
Host, can you assist or will be flexible, Mr. James? Whichever
Yes, Chair.
makes you comfortable.
Perfect. Thank you so much. Okay. Right. So, can you see my screen?
Yes, it's there. Thank you.
Wonderful. Okay. So to begin with, I just want to emphasize that we agree with many of the bill's provisions, particularly those ensuring efficient processing, applicable relevant laws. However, we do feel that perhaps in some aspects, if it were amended, it would provide greater protection in line with the Bill of Rights, enhance response to and combat corruption, and ensure that vulnerable individuals crossing the border safe and orderly migration is secured. In line with this, we recommend that the Department of Home Affairs maybe consults with the UNHCR and other stakeholders in devising bilateral treaties with regard to protection-sensitive entry systems at one-stop border posts to ensure non-refoulement or obligations are fulfilled. And I'll speak to that a bit in the further aspects. We further recommend that the bill expressly refers to addressing combating corruption at the border and includes legislative mechanisms to that effect, as well as provides protection for fundamental human rights as enshrined within the Section 2 of the Constitution, the Bill of Rights. We can see in the memorandum of the objects of the bill that the supremacy of the Constitution is mentioned. And I've quoted it there, but it's not actually a reference specifically in the bill itself. And we would recommend that the supremacy of the South African Constitution is expressly mentioned in the bill itself. We also are aware from extensive experience that there's very little to no signage at the borders in terms of process, particularly for vulnerable communities. And so we recommend that there's better signage at your one-stop border posts so that authorities can communicate to vulnerable individuals crossing the border, including asylum seekers, children, could be unaccompanied and separated children, trafficked persons, or stateless people. And so when we look at the bill, and in particular going to specific sections, we look at section 3(1)(c). It talks to providing for authorizing authority to officials. It talks about law enforcement. It talks about arrests, search, seizure, and detention. But it would be amplified and improved if it also speaks to ensuring the application of fundamental human rights and protections as an additional subpoint Roman numeral 3 to ensure fundamental human rights and protection under Chapter 2 of the Constitution, including protection and processing of asylum seekers, refugees, children, survivors of human trafficking or torture, stateless persons, and other vulnerable individuals. The risk that you face if you just enable arrests, search, seizure, and detention is that you could have somebody who fled from persecution, war, or violence, like a refugee or an unaccompanied child, being returned and denied entry, You could have a survivor of human trafficking entering without being picked up because you don't have proper identification that takes place at the one-stop border posts. And so these are things that really do need to be addressed, likewise with respect to stateless persons. We also, just to in line with that particular recommendation, we recommend that the definition section itself provides definitions of unaccompanied and separated children, of asylum seekers, of stateless persons, so that they can be referred, where they're referred to expressly within the bill. As I mentioned, the not denying of entry is supported by this subsection Roman numeral 3 that I suggested. Then in terms of section 5.1 of the bill, it speaks to where an act or omission constitutes a criminal offense in an adjoining state committed, then that might be addressed, taken into account. It really does need to say non-political, because we know that a person may have committed a political offense as they strive for sort of freedom from oppression. They advocate for a particular political party, and political persecution is one of the listed grounds in terms of the refugee conventions, in terms of our refugee law. And so it needs to be expressly left out. You can even see in the Refugees Act itself, Act 130 of 1998, the exclusion section, section 4.1b, talks about being excluded from refugee protection if committed a crime outside of the Republic that is not of a political nature. And I emphasize that because the whole basis for refugee protection is to protect people, including people who fled from political persecution. And so, like, trumped-up charges by states and political charges cannot be a justification for denied entry. And then lastly, I mentioned the principle of non-refoulement, that you cannot deny entry to refugees, asylum seekers. And in fact, the 1951 convention, the 1969 OU Convention on our domestic law, in terms of section 21.4, also includes that you cannot penalize or punish somebody for not having proper documentation, because often a refugee or asylum seeker would flee their country only with the shirt on their back. And to deny somebody and return somebody to face torture, persecution, and violence is not tenable. And so we need to make sure that the one-stop border post legislation, the bill, provides for section 21.4 in line with also Article 31 of the 51 Convention. So not barring entry for people who are seeking asylum or people who fled torture. And so you'll see we talk about subsection 3, the Republic is required to apply refugee law and customary international law to ensure protections provided to asylum seekers and stateless persons, and that individuals are not returned or remitted regardless of legality of entry. And then I've just quoted there section 21.4 for ease of reference. Those are my submissions. Thank you very much for the opportunity to present.
Thank you, Mr. James. Thank you so much. Then I hope the honorable members are taking notes, and please stay alert for any question for clarity later. Can we then give the platform to the representative of Agri SA, Ms. Thea Liebenberg, and Mr. Jason Kum. And as Chair clearly indicated, please apportion the time amongst yourselves. Your 10 minutes starts now. Thank you.
Good morning. Thank you for the opportunity and all protocols observed. My name is Jan Sarabi, not Thea Liebenberg, not Jason Kum. I'm from Agri SA, a legal consultant on behalf of that organization, and presenting this morning on Agri SA submissions on the one-stop border post bill. Chair, I see that I'm not being afforded the opportunity to flight my screen. If that could be made possible for me, thank you for that. Much appreciated. I hope you can see my presentation now.
Yeah,
I
it's
presume
coming.
that
It's coming. Thank you. It's there.
Thank you, Chair. Agri-SA is the largest organized agricultural organization in the country, representing farmers from commodity bodies, agricultural business, the whole value chain within agriculture. It's an old organization, 120 years old. It's not a political organization. It's an organization solely focused on agricultural issues. But obviously, pardon me, the legislation and legislative developments have a significant impact on the sector. So our position with respect to this bill in particular is that we do support it. We feel that reducing border delays is important for agriculture, given the time-sensitive nature of perishable products in particular. But there are issues with respect to implementation that do need to be raised, and which we do so in this presentation this morning. Our four priority concerns are biosecurity and agricultural risk, regulatory complexity and legal certainty, in particular as a second point, perishable goods treatment as a third point, and then institutional coordination as a fourth point. I'll go through each of these thematic concerns by Agri-SA in turn. With respect to biosecurity and agricultural risk management, agricultural sector is for obvious reasons very concerned with respect to biosecurity, which is a non-negotiable for agriculture in general. Efficiency gains, as proposed by the bill, must not be achieved at the cost of disease control in particular. The bill is presently silent on how biosecurity protocols will work inside common control zones, and this needs to be explicitly addressed. In that regard, also the present foot and mouth disease, which the agricultural sector is grappling with, is pertinent and needs to be noted as well. With respect to regulatory complexity and legal certainty, dual jurisdiction rules are inherently complex. Agricultural producers need certainty with respect to that, obviously. Conflicting sanitary and phytosanitary standards between South Africa and neighbouring states within the same zone could create real operational headaches for exporters, which we alert the committee to. And we emphasise the need for that alignment between sanitary and phytosanitary standards and ensure that accessible operational guidelines are developed for all users, particularly smallholder farmers and smaller agricultural businesses, which sometimes do not have the luxury of having those compliance measures within their organizations as such or within their businesses as such. The third item, which Agri-SA raised in its written submissions and highlight here again, is the treatment of perishable agricultural goods. Agriculture is for obvious reasons time critical. Fresh produce such as cat flowers, livestock, all kinds of delays simply destroy the value of those commodities. And this is one of the most concrete and practical changes we asked the committee to require in the regulatory framework. That explicit provision for prioritized processing of perishable agricultural goods supported by dedicated inspection capacity, cold chain compatible infrastructure, and clear service standards at priority trade corridors, as highlighted in the slide. Fourth, Chair, and drawing to a conclusion, with respect to institutional coordination and stakeholder engagement, the Department of Agriculture must not be an afterthought with respect to this bill. It is the primary regulator of agricultural imports and exports, and formal inclusion in governance structures is certainly non-negotiable for the sector. We therefore recommend that the committee should ensure proper coordination between all departments, including the Department of Agriculture, and that structured ongoing engagement with organised agriculture is provided for in the legislation and its regulations. In summary, Chair, we support the bill in principle. Its objectives are aligned with the needs of the agricultural sector. We've made the point about biosecurity, which must be explicitly provided for in the bill. With respect to perishable goods, we've made the point that this needs to be prioritised within the operational framework and key trade corridors. Sanitary and phytosanitary standards must be aligned with clear guidelines provided for the exporters and transporters. And then the Department of Agriculture and organised agriculture must be formally included in governance. We request that the committee adopt the bill with due consideration for our recommendations. Chair, with that, I thank you. And if there's opportunity for questions, then I am available to do so. Much appreciated.
Nkosi?
Sorry. I don't understand. My gadget was not allowing me. Meneer Jans Rabi, thank you so much for presentation. As I indicated to your colleague, please bear with us, wait for us. We would like to interact to understand fully this important contribution. Mr. Bekani Tabede or any mandate or representing him, the floor is yours.
Good morning, honorable members. I think I'm audible.
You are, sir.
Okay, thank you very much for the opportunity that you've been given to me. Firstly, I would like to applaud the Home Affairs and also the Parliament in engaging with us as communities in whatever law that is going to be implemented so that they can get the feeling from our side. From my side, let me say this is a positive initiative. Whoever that came with it or with the idea, I think shows that he's living in the now or in the present. So I applaud them.
Yeah, thank you. Just hold on there.
Yes.
Jans Rabi Meneer, you still appear on my screen. I don't know. Can your name be removed? Thank you. Proceed, Meneer.
Okay. On 2 points, this will make a cross-border operation a smooth and efficient process. It will also help in avoiding working in silos of various stakeholders that works in the port of entries, because we know there's lots of sections that facilitate the movement of goods and personnel across the border. So with this one-stop border post, I think it is going to be efficient and very fast. And it won't be frustrating to travelers that are coming in or going out of the border. However, while appreciating this, I also have a different view because it is a good idea. But my worry is that our focus is mostly on the new development and this process that we are doing on the border posts. But the issue that we are ignoring is the borderline itself, the physical borderline, which is along the border posts. It's good that in the port of entries, everything could be running smooth. But what do we say about the physical borderline that is along the borderline, which is very vulnerable? Like I'm from KZN, the borderline that I know from Kosi Bay to the beginning of Mpumalanga is about plus minus 250 kilometers. And it covers Mozambique and Swaziland, who are our neighbors. But the issue now is the physical border line is very, very poorly maintained. And in some areas, it's not even there. And that's a state of concern because we can have beautiful act that we provide and enforcement that we do on the port of entries itself. But we cannot ignore what is going on along the borderline. The borderlines are rusted. In some cases, they are not even there. People can walk in and out as they wish. So the issue of the fence or the border demarcation between ourselves and our neighbors should be taken into consideration. On the issue of manpower of different stakeholders, which I think we've got SANDF, SAPS, Border Management Authority, and others. I don't know if the manpower is enough to maintain the borderlines. And also, do they have enough or efficient equipment to guard our borderlines in regard to in working people and outgoing people? And also, there's another elephant in the room, which is the V-gates. There are uncontrolled openings along our borderlines between Mozambique and Swaziland. And it's a pity that nobody owns up to its existence. The local authorities, like your tribal authorities along the border fences, they've got an understanding, which I don't know which department approved it. And the problem is those border openings or gates that are opened on the border, and they are not controlled. So yes, it's for the communities that share the same tribe from both sides of the line. But now the issue is, how do you check which one is not from the communities? Because anyone can walk there and act as if he lives in these communities that are along the borderline. And that's where you're gonna have a problem of people that are taking in stuff or taking stuff out of our country. And that is when also we have a problem of education issues where children from neighboring countries walk in the morning to our country to study and go out in the afternoon to their country. Also, people who come to access our health services like the clinics that are along the border. I guess when it's prepared or it's only for people that are in South Africa or in those communities, but it ends up catering for people who are coming from the neighboring countries, which I think that talks to our budget and on a negative way. And also, my wish is to invite the committee whenever they've got time to come and visit these places to experience practically what is happening, because we can have beautiful laws that are passed, and obviously most of the people that comes to the border uh, port of entry, there are people that have all the documentation most of the times. It's very rare to find that there are people that are not ready to be facilitated because they know the security is strict and there are officials that are looking after that. But my concern is the borderline. Hence, I'm requesting the committee to actually get time to come and check the status of our borderline. I think for now, that is my presentation, Chairperson. Thank you very much.
Well done, Mr. Tabet. Thank you so much. I think your message is loud and clear. Can we now accommodate Mr. Zanele Zatsikau? And I hope, Mr. Tabet, you're not going away. You will be part of us until we adjourn. Mr. Tsao?
Good morning, everyone. I stand on the protocols already established. So I have shared my presentation as a whole with the Secretariat, but I'm going to touch, for purposes of this session, on the points that I would like to emphasize. And if you can, colleague, move to the slide, return the abstract. Okay. Worth noting here, colleagues, is that the rollout of the one-stop border post has economic significance for SA, as that will boost the implementation of the African Continental Free Trade Area Agreement. And owing to the rollout of the one-stop border post, there's a potential of a 1% rise in South Africa's international trade, and That, if you look at the continent as a whole, would create a further $70 billion in income for the continent. If you could please move to the introduction. Of course, one-stop border post is a geographical area where one country's authority over the movement of goods and people begins. And what you then find at the border post is that there's a multiplicity of agencies operating on both sides of the border post, which then doubles the bureaucracy. Next slide, please. Okay, looking at the background, I'd like to underscore that the concept of one-stop border post promoted a coordinated and integrated trade facilitation approach. And one-stop border posts will not only decrease the costs and delays incurred by companies and and enhance competitiveness. They will also boost government revenues and accelerate economic growth. This process of one-stop border posts eradicates the need for travelers and goods to stop twice to perform crossing formalities. This concept also again calls for application of joint controls to minimize routine activities and duplications. Furthermore, the concept reduces journey times for transporters and travelers and shortens clearance time. If we look at the Chirundu one-stop border post between Zambia and Zimbabwe as an example. So before the establishment of that one-stop border post, the border handled more than 6,000 trucks each month with an average of 225 trucks per day. Then the Statistics Agency of Zimbabwe later reported that it estimated the value of the goods passing through the border post to be around $1 billion per year. And in 2009, of course, Zimbabwe and Zambia commissioned the one-stop border post. And as a result of that, if you move, please move to the slide which says the case of Chirundu border post. Again. 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 Yeah, on this slide. So subsequent to the establishment of the one-stop border post, an evaluation was done which highlighted several benefits for establishing a one-stop border post, and those benefits included reduced supply chain transactions, increased government revenue, reduced duplication of efforts, reduced retail price of consumer goods, and promoted investment and growth. I shall move to the next slide, which is on lessons and interventions needed. Okay, one of the issues that need to be addressed is the facilitation of cross-border transport of goods and people, and the harmonization of cross-border procedures and custom policies. And further down, it is important that to note that the rollout of one-stop border posts will create bigger markets and economies of scale, and also strengthen economic relations and enhance economic development. And as I conclude, Chair, it is also worthwhile to note that improving and harmonizing customs procedures as well as addressing crime at borders can considerably reduce trade costs and increase government revenues. And also improving customs clearance efficiency will improve productivity and competitiveness. And ultimately, the rollout of one-stop border posts and the free movement of goods and people can make an immense positive contribution in implementing the African Continental Free Trade Area Agreement, leading to economic growth and development. And the very last slide is recommendations, Chair. And I would recommend that these one-stop border posts be constructed as construction and operational effectiveness of these border posts is required. And worth noting again is that the movement towards more integrated agencies ought to resume with analysis of each border post mandate, existing procedures and operations. And informed by research findings, a new set of joint operational procedures needs to be agreed upon. And a governance model for a joint border post will have to be defined, including financing modalities, operational framework, and delegation of different responsibilities. After the joint border post is in place, a monitoring and evaluation system should be in place to measure impact of the changes and to identify possible bottlenecks at the border post. And the last point, Chair, is that operational procedures for all border crossing agencies should be designed, leading to the development of common documents and integrated procedures. Thanks a lot, Chair, and fellow presenters.
Thank you, Mr. Strau. Thank you so much. We really appreciate your contribution, and as I indicated to your colleagues, please wait for us for any further engagement. Mr. Tsepo Palazzi, are you here? And we are all yours. 10 minutes start from now.
Honorable Chairperson and members of the committee, good day, everyone. I'll just like to show my face just to say the greetings, but I'd like to turn my camera off due to bad network this side. Thank you.
Agreed. We'll appreciate seeing you. Thank you so much. Do as you please.
I therefore support the objective of the bill, because the goal is to reducing congestion, improving movement of people and goods, and making border processing more efficient, because it's important and understandable. However, efficiency alone cannot be the only standard. The bill must also protect legality, accountability, accurate record keeping, sovereignty, and the constitutional rights of all persons affected by border decisions. My submission is therefore not opposing to the bill. Rather, it asks Parliament to strengthen the bill so that one-stop border posts do not become spaces where one can say unlawful entry, identity manipulation, or other forms of abuse can later be hidden or regularized through weak records and weak oversight. If we can remember clause 4, is one of the most important provisions because it allows the laws of each state to be applied and enforced by that state's officials within a common control zone, even when that particular zone is located in the territory of the other state. That is a major legal arrangement, and it must be governed by very clear safeguards. In my view, I can say that the committee should ensure that the agreements and regulations under this bill, they contain detailed operating standards on identity verification, handling of refusals, information sharing, and compliance procedures, because this is necessary at the border enforcement decisions so that they do not end at the border. They may later affect immigration statuses, residence applications, and the integrity of future legal processes. And also clause number 7, if we can all remember or maybe later go to it, is practical because it requires the state from which a person, vehicle, animal, merchandise, or other goods arrived to readmit them where entry is refused or illegal entry occurs outside a designated port of entry. However, practical arrangements must still be fair, reviewable, and properly recorded. I therefore recommend that readmission decisions be supported by written reasons or recorded grounds, together with the date, place, and responsible authority. An auditable record will help reduce disputes between states, support legal review when necessary, and create a reliable evidentiary trial for future immigration and border-related matters. And clause 8 also, if one can also go back to it, which I would like to emphasize on, it gives the minister broad power to make regulations, because so much of the practical implementation will depend on those regulations. Therefore, the parliament should not leave all the important detail open-ended. The bill should require minimum subject matter to be covered in the regulations. At a minimum, at least, the regulations should address record keeping, access to information, compliant procedures, detention standards where applicable, data sharing safeguards, anti-corruption measures, and procedures for detecting document fraud and identity fraud. Therefore, these matters are directly connected to the scheme of border enforcement and readmission in the bill. And I would also like to emphasize, therefore, that immigration integrity is a concern, because I raise a constructive concern about the downstream effect of border processing on immigration matters. As once in a while, a person may later seek to benefit from South African immigration processes after an unlawful or unverified entry, including through marriage or spousal relationship. That issue is not about blaming any group. It is about ensuring that the legal system has reliable records. Therefore, the bill should not be framed or applied in a way that assumes guilt based on either sex, nationality, or marital status. Instead, it should ensure that all persons are subject to the same lawful standard of verification regarding identity, lawful entry, and the authenticity of any later immigration-related claim. For that reason, I submit that Parliament should strengthen the bill or its regulation so that one-stop border post systems do not make it easier for any person whose entry was unlawful, undocumented, or fraudulently recorded to later benefit from immigration processes through sham marriages, false identity claims, or unsupported spousal status applications. The focus should be on evidence, equal treatment, and anti-fraud safeguards. Therefore, I suggest the following improvements. The improvements I respectively propose are as follows: reliable and interoperable records of all admissions, refusions, therefore refusals, readmissions, and enforcement actions. Regulations dealing specifically with identity verification and document fraud, written reasons for refusal and readmission decisions, a complaints and oversight mechanism, express respect rather for constitutional rights and non-discrimination, and safeguards so that border records can assist in detecting and preventing fraud in later immigration processes. I can conclude my submission in the following manner. The One-Stop Border Post Bill has an important operational purpose and may improve trade facilitation and movement and land borders. But because it creates a framework for shared enforcement powers, cross-border legal application, readmission, and broad future regulations, Parliament should strengthen its safeguards for transparency, rights protection, accountability, and anti-fraud enforcement. Thank you, everyone, for the chance that I've been given. That's all from my side.
No, thank you so much, Mr. Palazzi. Thank you so much. Before I give the Department of Home Affairs, Mr. Malakate, I'm told, I just want to make sure in the few seconds and minutes I have, whether I've done justice to Agri SA people. Can Mr. Rabi confirm that he was representing both Thea Liebenberg and Janssen Kum?
Chair, I confirm.
Thank you so much. Thank you so much. That being the case, Mr. Malakate, this is your opportunity. Can you then, I hope you have listened carefully, and in fact, I hope you did receive, like ourselves, the very good submissions that have been made by all the presenters this morning, circulated to us. And now, before we ask any question for clarity, we would like to listen to your responses to their suggestions or proposals to the bill before us. Thank you, Mr. Malagate. We are all yours. We have given you how many minutes? 30, but you can take 15 or 20. Thank you. But anyway, take your time and respond to the submissions.
Thank you very much, Honorable Chair, Honorable Nonkonyane, and good morning to the members of the Select Committee. Our special thank you and good morning to the presenters today who made oral submission to the Select Committee. Mr. James Chapman from Scalabrini, Mr. Jan Serabi from Agrisa, as well as Mr. Tabet, Mr. Stau, and Mr. Palati. Chair, we did receive, as the department, both the presentation from the content advisor as well as the summary of the written submissions that have been received by the Select Committee. We have looked at the written submissions. We compiled our presentation on the basis of the written representations, but we are also taking into consideration, Chair, the oral submission that have been made today, and in the main, they seem to be the summary of what the written submissions are. And in particular, Mr. Chapman deals with issues related to the asylum seeker management and how the state should be able to protect the vulnerable groups as well as those who may be termed to be stateless, so that we do not fall foul of the international obligations that South Africa is signatory to. Mr. Rabi also deals with issues that Agrisa had also indicated related to biodiversity, but also related to stakeholder management and the involvement of the Department of Agriculture, in particular, in the mandate that has been given to the Border Management Authority in respect of implementing legislation that affect border management within the border law enforcement area, as well as at ports of entry. So, Chair, in the main, we are going to deal with all the written submissions, but also with the oral submission that we have had. So, Chair, the next slides just basically deals with what has already been submitted. And Chair, if you would allow me, we can start at slide number 8, which then begins to deal with the written submissions that have been made, both from Mr. Tabete, also Mr. or Mrs. Ngozo. In the main, in this slide, Mr. Tabete has already indicated and raises the same issues that we need to have a look at our borderline. More importantly, today, he also raised the issues related to those informal or illegal community crossing points that we need to turn our efforts and our eyes into, and he calls them the V-gates. He also he urges the Select Committee or invites the Select Committee to do oversight, in particular within the borderline environment, as well as the at ports of entry to assess the operational realities that he has indicated and submitted to the Select Committee. Also, Mr. or Mrs. Ngozo has also reiterated that the Department of Home Affairs needs to improve its systems and also strengthen the migration management. And in the main, the recommendation from it then becomes that African countries should be encouraged to improve the efficiency of their Home Affairs systems, but also to strengthen migration management processes and explore alternatives to frequent passport stamping. In the next slide, Chair, we then deal with our responses, and in the main, Chair, we submit that the issues that have been raised in the two written submissions that we have just spoken to are in the main operational issues, and we resubmit, and we wish to place on record that you would recall, Chair, that the Republic of South Africa has established a border management authority to deal with border management issues. And key in the establishment of the Border Management Authority is to ensure that the fragmented approach in border management we do away with, and we have a singular entity that deals with border management. Hence, we have the BMA, which is now currently comprised of following the president's signature and gazetting of the Section 97 proclamation. It's comprised of the immigration unit from the Department of Home Affairs, the Department of Agriculture. It's comprised of the Department of Health, as well as the Department of Forestry, Fisheries, and the Environment. So all the functions that were performed by officials from these departments at ports of entry as well as the borderline are now mandated to be dealt with by the BMA. So the BMA is responsible for that, and my colleagues from the BMA are also present, Chair, and they could reiterate and concur that they have them now the mandate fully to deal with issues related to border management within the border environment. So all the operational issues that have been raised have been taken care of and have been noted, and we will deal with them from the BMS side in terms of operations. There was also an issue, Chair, that we need to clarify, that the written submission presupposes that the Republic of South Africa must ensure that each and every individual who enters the Republic of South Africa, they must have been issued with a passport or a travel document. And we just want to clarify and place it on record that the Republic of South Africa is only responsible to issue passports to its citizens. And those who wishes to enter the Republic of South Africa must be issued with passports or travel documents from their country of origin. That is the responsibility of the country from which they come from. However, what the Republic then regulates and through its implementing agents, which is the BMA, and which we have abbreviated as the authority, it ensures that entry into and departure from the Republic is dealt with as required in terms under the Immigration Act. But of course, looking at all other pieces of legislation that are applicable within the Republic of South Africa, from the Constitution itself right to the Refugees Act. We will further wish to submit that when it comes to issues related to efficiency of the systems and management of migration and how ports of entry operate, we believe that these are issues that are outside of the scope of the draft bill, but we have taken note of them, and that when it deals with issues related to systems, the BMA will deal with that, as well as issues related to ports of entry operations and my management of migration. Chair, we also need to reiterate that whilst this bill only seeks to empower the Minister of Home Affairs to establish this one-stop border post, and also tries in a minimum way to set the parameters of how the minister would be able to execute this function. It does not delve into operations because these are issues that would need to be negotiated and agreed to with the adjoining state when we establish this one-stop border post. So there would be a procedures manual that would be compiled, and it will be compiled following engagement with the neighboring or the adjoining state and following the agreement. And there would also be bilateral agreement that would then the Republic would have to enter into with the adjoining state in order to establish one-stop border post. So some of the issues that have been raised in both in the oral submission as well as the written submissions would be dealt with either in the procedures manual or in the bilateral agreement that the Republic would then enter. If we can move to the next slide. So here Mr. Palazzi, again, you would have heard today, his submission more relates to ensuring that we deal with identity fraud, that we properly manage migration, and that there has to be our systems, for lack of word, has to be jacked up in terms of verifying all this identity or all these passports to ensure that there is no identity theft, and ensure that we've got proper record management. And he makes an example in terms of clause 7, where we then deal with issues related to readmission, that there has to be a proper record keeping when entry is refused and the person is it's refused entry into the Republic and then sent back to the country of entry, that there has to be proper recording related to the reasons why that individual may have been refused, or if it's a vehicle, such reasons. Mr. Strau, you would have heard even today that he supports the thrust of the bill, safe to indicate that the benefits of establishing the one-stop border post. And he mentioned correctly, Chair, that South Africa is signatory to the AfTA agreement, and that the establishment of the one-stop border post allows the Republic to ensure that its obligation under that agreement are well taken care of, and that there is proper management of entry and departure from the Republic. But he also deals again with issues related to data sharing, and also issues related to adoption of international border management standards. So as I've already indicated, some of the issues will be dealt with in the bilateral agreements, but also in the procedures manual that the adjoining state would need to enter into. So in the next slide, we are dealing with our responses as both the department and the BMA. And off the bat, we indicate that we note the comments and the suggestions that have been submitted, and we submit that some of the issues that have been submitted in the written submissions require to be taken care of in the draft Citizenship, Immigration and Refugee Protection Bill. Chair, just to pause, you would recall that in March this year, Cabinet, not Parliament, my apologies. Cabinet approved the revised white paper on citizenship and my immigration and refugee protection. So we, as the department, we're in the process of developing the draft bill to give effect to the revised white paper. And we anticipate that as it appears in the department's annual performance plan, that by the end of 2027 we would have finished and finalized every aspect relating to the development of this bill, and that bill will then need to be subjected to public participation process. We have also noted that some of the written submissions deal with operational issues, and we confirm that both the department as well as the BMA will take that into consideration, and will develop systems where there is a need to do so but also ensure that there is harmony in terms of the operations. Some of the recommendations, as I've already indicated, would be dealt with in the bilateral agreements that the Republic will need to enter into with the neighboring countries in order to establish these one-stop border posts. Also, the procedures manual will deal with some of the operational issues that have been raised. In the next slide, Chair, we deal with the submission both from Scalabrini as well as the Catholic Parliamentary Liaison Office. Chair, in the main, as Mr. Chapman had also indicated this morning, in the main, the issues that Scalabrini and the Catholic Parliamentary Liaison Office deal with are issues around refugees, how the Republic would ensure that those who seek refuge would be allowed entry into the Republic, as well as the process that would be followed in allowing such entry. And Mr. Chapman then goes further to indicate that perhaps the draft bill must be amended and enhanced to ensure that it takes into consideration issues related to asylum seeker, issues related to how the Republic accepts vulnerable groups, including those who are regarded as stateless persons. And in our view, Chair, this is what we deal with in the next slide. We believe that this draft bill should not go further to deal with issues that are already catered for in other pieces of legislation. How the Republic of South Africa receives and processes asylum seekers and refugees, there is already a law that deals with that. The submission, both in the written and oral submission made today, to define certain terms, for instance, unaccompanied minors, for instance, what is meant by refugee, what is meant by a stateless person. Those are there already exist definitions in the Refugees Act that deals with that. So the BMA in executing its functions, in as far as it relates to receiving or allowing entry into the Republic of those who seek asylum in the Republic, follows the Refugees Act, but it's also guided by the international instruments relating to protection of human rights, but also take into consideration the constitutional principles that are embedded and enshrined in the Constitution of the Republic of South Africa. So we believe that the draft bill as it is should not be expanded or amended to deal with issues that are already regulated. And that, in fact, the Border Management Authority, in executing its functions, cannot do so to the exclusion of these other pieces of legislation. They do so, and they take into consideration that. We also need to indicate that as part of the efforts of both the BMA as well as the department and the Republic as at large, when in redeveloping our ports of entry, issues related to signage should not be dealt with in the bill, and as we believe that is operational in nature, and that in the redevelopment process, of course, and it is part of the issues that the redevelopment efforts is taking care of, that will be dealt with in that space, and that the bill should not and cannot therefore deal with this aspect. We further wish to submit, Chair, you would recall that there has been submission both from Scalabrini and other presenters today that they are raising issues relating to the Republic's ability to deal with corruption within the borderline, but also at ports of entry. And we have noted these recommendations relating to anti-corruption at ports of entry, and we wish to submit that the BMA, through the Border Management and Immigration Anti-Corruption Forum, continues its effort to deal with fraud and corruption, both at ports of entry as well as the borderline. That in fact this bill should not deal with issues related to anti-corruption, because there is already pieces of legislation that have been developed and adopted and approved by Parliament and signed into law by the President of the Republic to deal with anti-corruption issues. There are already in place anti-corruption measures that this bill should not be expanded or amended to deal with those issues. Chair, in the next slide, we then again deal with written submissions that come from both Scalabrini and this was in relation to the redevelopment of ports of entry, and they refer to the memorandum of the object on the bill, and we agree that you would recall that there is a redevelopment of ports effort under the stewardship of the BMA that they are dealing with, and there is a triple P model that has been adopted. So the draft bill should not deal with that. Those are already in place. That needs to be dealt with, and it will be dealt with there. Agrisa then submits to the select committee, and their starting point, as we understand it, is that Agrisa supports the bill in principle, but also requests the select committee to ensure that the final legislation adequately addresses agricultural trade, biosecurity, and other operational requirements. And the Agrisa then recommends that the select committee should ensure that there is proper coordination between departments, including the Department of Agriculture, and the structured engagement within organized agriculture is provided for. As we have indicated, Chair, this bill, in the main, its primary object is to empower the minister to establish one-stop border post, but also to empower to ensure that the Republic of South Africa is able to enter into bilateral agreements with adjoining states in order to establish one-stop border post, because we cannot establish OSBPs without the concurrence and agreement of adjoining states. It requires both states to agree to the establishment of the one-stop border post. So that is the primary object of the bill. Issues related to coordination between departments. These are issues that the BMA deals with. So if you were to go and look at the Border Management Authority Act, you would realize that in terms of Section 4 and 5, read together, there is a clear mandate that is given to the Border Management Authority to ensure that there is stakeholder management, but also ensure that there is proper coordination between organs of state in as far as it relates to border management. In the next slide, Chair, I have just dealt with this, and maybe just to emphasize the fact that the Department of Agriculture, in fact, it's part of the statutory established coordination committees in the BMA. We've got the Border Technical Committee, which is composed of the Director Generals of various departments, and the Department of Agriculture is part of that coordinating committee. We also have the Interministerial Consultative Committee, composed of ministers of departments that are impacted by border management, and the Department of Agriculture is also part of that committee. So there is proper there's legislated coordination model in terms of the BMA. And we just wanted to reiterate that the Department of Agriculture is part of that coordination model. And let's move to the next slide, where the next slide, Chair, then deals with the substantive comments that have been provided by the presenters today relating to specific clauses within the bill. I have already dealt with clause 1, which was a submission from Scalabrini and CPLO relating to and the recommendation was that clause 1 should include definitions relating to unaccompanied children, separated children, asylum seekers, human trafficking, and statelessness, and that these terms should be expressly referred to in the bill. And we have noted the submission, but we are of the considered opinion that there are these definitions already appear in various pieces of legislation in the Republic. And as an example, we give we indicate that Section 1 of the Refugees Act already defines what is an asylum seeker. And if you were to go to the Children's Act also defines what is an unaccompanied children or separated children. So we do not need to deal with this. The trafficking in persons legislation also deals with issues related to human trafficking or trafficking in persons. And this bill should not, therefore, be amended to, we believe, and we submit that the bill should not be amended to define this or to include these definitions as they already appear in our jurisprudence. The next slide. The next slide deals with clause 3, the common control zones. And I think Mr. Chapman had then made an oral submission, which is akin or the same to what appears in the written submissions from Scalabrini and together with the CPLO. And we agree that the Border Management Authority, and we re-emphasize that the Border Management Authority, in dealing with its mandate to ensure that there is proper coordination of entry into the Republic, but also exit into the Republic, and as far as it relates to the Immigration Act or all other pieces of legislation that are applicable within the ports of entry and borderline, that the BMA deals with it. But the submission here was that it has to be explicitly provided for in clause 3.1 C to that the in executing its functions there would be full compliance with the 48-hour maximum for detention before a person appears before a court. And a court looks at the lawfulness of the detention and makes the appropriate order. And in its submission, it then refers to the various cases that we're dealing with, Section 34 of the Immigration Act. Chair, we submit that the recommendation that has been submitted is properly and sufficiently dealt with in the new, if you can go to the next slide, Keshwin, that we wanted to indicate that the president this year, around March or April, signed into law the Immigration Amendment Act 2025, which Immigration Amendment Act deals with the Constitutional Court judgment in Lawyers for Human Rights versus the Minister of Home Affairs and others, where it was specifically ensuring that each and every person who has been arrested for purposes of deportation must be brought before court within 48 hours from the time of his arrest. That has been settled, The Immigration Act, Amendment Act deals with that. And this draft bill does not need to deal with those issues because they are properly dealt with. The Agrisa then further submits that in relation to clause 3, that the select committee should emphasize the need for alignment of sanitary and sanitary standard and ensure that clear operational guidelines are developed for users. We have noted the submission, but just need to submit that this, in our view, are policy issues that must be decided by either the Department of Forestry, Fisheries and the Environment together with the Department of Agriculture and all other relevant stakeholders in relation to policy development. And this draft bill should not deal with policy issues, that the issues related to sanitary and sanitary standards should be left for the department, for the relevant department to develop and to deal with. However, the BMA as an implementing entity will then need to implement those policy decisions that have been taken. And we again reiterate that the authority is always in constant contact with the Department of Agriculture on these matters, and that on the matters that relates to the policy decisions and directives or guidelines that may come from the Department of Agriculture. Next slide. In the next slide, we are dealing with the written submission related to clause 4. Clause 4 relates to the application of border law enforcement legislation within the border environment. And again, Agrisa reiterates the issues related to sanitary and phytosanitary standards, as well as clear guidelines. Mr. Palazzi deals with issues related to development of detailed agreements and regulations to deal with operating standard on identity verification, handling of refusal, information sharing, as well as the complaint mechanism. He further submits that these matters are important because border management, border enforcement decisions may later affect immigration status, resident application, as well as the integrity of the legal processes. We have noted this, and again, we have reiterated that if there is a need to deal with those issues related to standards, sanitary and phytosanitary standards, again, it's a policy issue, but some of the issues would also be dealt with in the bilateral agreement, but also the procedures manual that I spoke to earlier on. In relation to the submission from Mr. Palazzi, we have taken note of it, but we just want to submit that the issues that he raises are already regulated in our domestic laws. And then we make an example relating to information sharing and indicate that there is a particular provision in the provisions in the Protection of Personal Information Act and other pieces of legislation dealing with the security of information that deals with information sharing, but also lawful processing of personal information. And the draft bill, it is our submission that the draft bill does not need to regulate this. Similarly, issues related to identity verification, they're dealt with under the Identity Act, and some handling of refusals, complaints mechanism are operational issues that will be dealt with by the BMA. The next slide, we then deal with clause 5, which deals with application of criminal laws. You would have heard that Mr. Chapman submits that clause 5 should only or should indicate that be amended to refer to non-political criminal offenses. And they then submit that the word non-political should be inserted in the provision. And he made submissions to indicate that this is to ensure that we do not fall foul of the international obligation in as far as it relates to receiving and accepting refugees, and that we do not fall foul of the non-refoulement principle. We just want to reiterate that this clause is dealing with issues that are regulated under the Criminal Procedure Act, and that we need to confine ourselves to those pieces of legislation dealing with criminal offences, and that this bill should not therefore deal with or introduce something that does not appear in the Criminal Procedure Act. If there is anything that needs to be dealt with in terms of how we regulate criminal offences, the submission should then be dealt with in the revision of our Criminal Procedure Act, so that this clause can then be amended as the Criminal Procedure Act would have directed. However, we have noted the submission, and we're just reiterating that the primary focus is to ensure that the Republic's criminal laws are applicable extraterritorially, and where there's been contravention, there would be consequence management in relation to how we prosecute the perpetrator. So we think that in executing its duties, of course, the BMA will ensure that it does not fall foul of the principles relating to non-refoulement, and ensure that we are in line with the international standards. In the next slide, Chair, we are dealing with clause 6, which is dealing with the movement of money. You would recall that, Chair, this provision as it is, it was a subject of the coordination, consultation, and agreement between the Department of Home Affairs as the lead in putting together the legislation. But we discussed with both National Treasury.
Can't hear you. Okay, no, you are back. Thank you.
Oh no, Chair, I was just indicating that the development of Clause 6 was an effort or is a result of a consultation that the department had with National Treasury, with the South African Revenue Authority, and other organizations that are impacted by movement relating to goods or money. So what we currently have, it's an agreement that has been made, but we note what Agrisa is indicating. But in the main, that Agrisa is indicating that we need to ensure that agricultural goods, which are often highly perishable and sensitive, should not be subjected to unnecessary delays. And Agrisa therefore recommends that the provision should be made in the regulatory framework for the prioritization of processing of perishable agricultural goods supported by appropriate inspection capacity as well as infrastructure. And we also wish to indicate that the prioritization is operational in nature, and it will be dealt with by one within the competence of the BMA, together with all the relevant organs of state, in particular the Department of Agriculture, but also the bilateral agreement has to spell out the procedures that would be followed in relation to agricultural goods. So it would be part of the terms and conditions of the bilateral agreement that we need to deal with. and inspection capacity as well as the infrastructure related to this. These are part of the redevelopment efforts that the Republic is already engaged in. In the next slide, Chair, we deal with Clause 7, dealing with readmission. And Scalabrini, together with the CPLO, was just reminding us that we need to be mindful of what Section 21(4) of the Refugees Act indicates, that which is read with Article 31, and in the main, that we need to ensure that we do not refuse entry or penalize those who would have entered the Republic of South Africa unlawfully, or who are present in the Republic of South Africa unlawfully, but who in the main are seeking asylum in the Republic. And then the submission then was to indicate that subclause 3 should be amended to state that the Republic is required to apply refugee law, customary international law, to ensure that the protection is provided for to asylum seekers. And we again wish to reiterate that these matters that are raised here are clearly regulated in the Refugees Act, and the BMA as the implementing entity would ensure that asylum seekers are received and processed accordingly. And we submit that the draft bill should not deal with these issues. In the next slide, again, it's a submission from Mr. Palati, who then advocates for that the clause should be stronger in order to require that the BMA is able to take auditable record. So these are issues related to record keeping, but that most importantly, the records that are taken would need to deal with the date, the place, and the grounds for refusal or readmission, as well as the responsible person, but also deal with what authority does that person who took the decision to refuse entry has. We again wish to reiterate and submit that the draft bill does not need to deal with these issues. These issues are operational in nature, and that the bilateral agreements as well as the procedures manual would need to deal with. We also need to submit that also the standard operating procedures within the BMA would then deal with all this, with the issues that have been raised. In the next slide, we're dealing with the submission from Mr. Palazzi in as far as it relates to Clause 8, which is an empowering provision which empowers the minister.
Mr. Malate?
Hello?
Sorry to interrupt, man. Just remember you are on injury time. I want to start with the members. But anyway,
Okay.
I'm not stopping you. Just be mindful of wrapping up. Thank you.
Thank you, Honorable Chair. I'm wrapping up. I just wanted to indicate that this is an empowering provision, and Mr. Palati is correct to indicate that this will ensure the proper and efficient implementation of the legislation. But just to indicate that the issues that he is raising, they are already regulated in other pieces of legislation, and that we do not, the draft bill should not be amended to deal with these issues, and that some of the issues are operational in nature, and we will deal with them when we develop our standard operating procedures to give effect to this piece of legislation. In the next slide, Chair, we were just you would recall that the content advisor, in making the presentation the last time, they have dealt with two issues, and one, they submitted that there are these written comments relating or written submissions relating to the clauses. In our view, or in their view, this would need to be taken into consideration by the department, and that the department will be required to reflect on and responding, and we have just done so. The content advisor has also advised the select committee that the committee, depending on whether the committee is satisfied and understand the content of the written submission, the select committee may decide whether or not to host public hearings, which we have done now. Chair, we wish to submit that having considered the written submission as well as the oral submission, we are of the considered view that the recommendations do not substantively affect the clauses of the draft bill. That the clauses as they are, when considered against the written submission as well as the oral submissions, that they are in order, and that we believe that they do not materially affect the draft bill. And in our view, we were of the opinion that we were going to advise the the select committee that there would be no need to host public hearings, and that we would have dealt with from the written submission. But now that we are here and that the select committee has taken oral submission, we are then guided by the select committee decision, and that the department is always available. Chair, in the next slide, just it's our recommendations that the select committee knows the department's responses, and that these responses, Chair, were also compiled with the concurrence and consultation with the Border Management Authority. Thank you, Chair.
Well, thank you, Mr. Malkati. Thank you so much for comprehensive response. Members, and can I give you the opportunity, you can raise your hands so that I can recognize you for questions for clarity now, and you will be, of course, allowed to even ask the presenters and even then the department in that sequence. I'm not going to restrict you anywhere. But this is our time from now until 12:30. I see Honorable Noah's hand is up. Who else? Honorable Noah, so far is yours. Can we hear you, Honorable? And again, honorable members, I noticed that we didn't introduce ourselves to the presenters. If the member would introduce himself or herself, and then also then either comment or ask any question for clarity. Honorable Noah.
Thank you very much, Chairperson. My name is Peter Noe, all the way from the Free State, as a permanent delegate in the NCOP representing the African National Congress. And good morning to the honorable members, as well as our guests and officials from the department. And the chair, I think this has been a very good process, and want to appreciate in general the presentations by members from the public, as well as the comprehensive response by the department on each and every aspect that members of the public have raised. And this has been very much helpful. My first question, Chair, goes to Mr. Malakate, just to establish, because this will also helpful going forward on their recommendation or submission at the last, where it relates to whether we still need to go for public hearings. Whether all the public members who have made comments and representations on the bill were engaged based on their representations before today, or is it first time they receive the responses from the department, as it were, and in their own view, based on their responses, are they expecting somehow, if as from today members have received the department's responses on their submissions, will there be a further engagement? Will the members of the public again be given an opportunity perhaps to make second submissions on the basis of the responses? Just want to establish that. The last one, which is general, as I followed the submissions from the Agri-SA, I also noted what Mr. Malakate at least has partly covered, that some of the submissions to me appeared as though it is views which somehow indicate that some members will not have, before making submissions, considered whether the issues they are raising are not covered elsewhere in some bills. So I just want to establish whether members are aware of other applicable acts as far as control of management of the borders. And then the Mozambique and the Swaziland borderline, indeed, as a committee, we have not visited it. But I just want to establish from Mr. Tabet whether at all Parliament has never visited, or there was never any oversight visit by Parliament committees prior to today. And lastly, Chair, that goes partly to Agri-SA also, looking at the submission, especially that relates to, based on the summary that the organization made, whether before the bill was developed, I see those issues that are so important, such they couldn't have waited for this bill, whether what has been the attitude of Agri-SA before the bill was developed, based on the issues that are covered on the summary, or what is the existing current situation before the bill was developed, especially on the food, perishable food, and so on. Is there anything that you can share with the committee based on that? What is the current applicable situation as far as he is concerned, or the organization is concerned? Chair, I'll pause there. Thank you very much.
Yeah, thank you, Honorable Noah. Honorable Kharik.
Chairperson, good morning, and good morning to the colleagues. Chair, yes, we also appreciate and value the presentations as has been submitted by various presenters this morning, particularly also to the Department of Home Affairs. And we take note of some of the concerns and the reservations. As the EFF, we want to submit that there should be no blur areas whatsoever in this bill that will become legislation later on, that will be enacted. If you take we've got to give clear guidance and clarity on issues as has been raised by some of the presenters. The borderlines are porous at the moment, we know it is. And we need to hear from the department what they're going to do with regard to that. We don't want a situation where you shift the blame or you shift the responsibility to some other department. Yes, we understand that the mandates are different, but we need to have the assurance that as they want to engage cross-border governments, has this department engaged other departments internally, locally in South Africa already with regard to going forward? That is the mandate of Public Works. Has there been any engagement? What is the outcome of that engagement? Because it's going to be pointless to have this act and enforce this act if you have all those other shortcomings on your borderlines. And similarly, it is applicable to your ablution facilities and all the other issues mentioned and humanitarian issues when people rock up at the borders and so on. We also need clear-cut guidance on the issue of asylum seekers, because it would appear that there is at the moment some different interpretations with regard to asylum seekers, particularly these people going around searching people for their documents, demanding documents, and even when people are documented in South Africa, they still chase them around like dogs in our country. It can never be allowed. So we need to hear from Home Affairs, what is the position there? There's a lot of things that we can say, but our time is restricted as I am on my way on a flight to Johannesburg now. But we need clear-cut guidance from the Department of Home Affairs. We don't want grandstanding. We don't want a political grandstanding. We want a solution for the problems on our borders. Thank you, Chairperson.
Thank you, Honorable Kharik. Honorable Kharik is a permanent delegate from the Western Cape province. He's representing the party he has mentioned. Thank you very much. I see no other hand. Am I correct, Secretary? Is there any other hand that I'm missing from my screen?
No, that's correct, Chairperson. Thank you.
Thank you very much. Let's give first the presenters. If then you could actually not more than 3 minutes, just reflect on the response from the department in respect of your presentation to us, as well as clarity from the honorable members that have done so far. I can accommodate anybody, or must I call you in terms of those? Let's start with the Scalabrini. Do you have any reflection on what has happened so far? James Chapman.
Thank you very much, Chair and honorable members. Just to particularly response to the last point raised, that while we understand that other legislation does speak to certain aspects, including particularly the asylum and refugee protection, I think that the bill would be enhanced by express inclusion. And it can also refer to the other legislation, so they work in a harmonious way, in the same way that the white paper proposes harmonizing various other legislation. So we would still stick by our position that express inclusion of certain protections, constitutional protections, refugee asylum protections for non-political, for political actors, where there's a refugee claim, a political persecution claim, should be provided for. That would help ensure that the refugee protection that is required is catered for. Thank you.
Thank you, Mr. James. Agri SA?
I'm trying to switch on my video. Chair, thank you for the comprehensive responses. Our intention is to engage on the legislation. The issue is not the current situation at border posts as such. If you care to, we'd be happy to engage with that, but it's well documented what the bottlenecks and traffic queues are at the Lebombo border crossing with Mozambique and Beitbridge with Zimbabwe. If the honourable member wishes to engage, I think we'd be happy to do so. We've also, with respect to perishable goods, there's a track record, I suppose, of where things can go wrong and how bad it is when they do go wrong. So the spirit of Agri-SA submissions with respect to the recommendations on the bill was to enhance the current situation, to make sure that in the transition, which we know will have effects, that that transition takes place in a smooth and coordinated manner, and that the intention of the bill is actually adhered to by making sure that the border posts function and the system proposed functions better than what it is at present. Other than that, Chair, I think the points were made in a spirit of cooperation, and as I said, Agri-SA supports the bill as it is. So from that point of view, thank you for the explanation. Also, thank you for the clarification on the border management authorities and the current processes to integrate, especially the Department of Agriculture, with respect to agricultural produce. I'll leave it at that, Chair, unless there are other further questions or comments.
No, thank you, Mr. Rabi. Mr. Tabede.
Ngiyabonga kakhulu kumkhandlu. Thank you for the response from the department. I think it's well narrated, it's very clear, but however, my concern was that you cannot put a beautiful gate in your household, but not fence the surroundings, because people may enter on the sides and forget about the gate. So I just wanted them to also focus on the borderline, as it indirectly or directly affects what is going to be happening in the border post. And I also don't know, Chairperson, if I can respond to the question by Honorable Noah at this moment.
Go on, please.
Okay, maybe in short response, yes, there have been some oversights that I know. It's only from the local, like provincial parliament, from the times of Honorable Premier Musa Dube. She visited these places, and also the current Premier also visited these places. But there has not been any changes. They just come and visit and promise that they're going to fix 1, 2, 3, and they act very surprised every time they come, but nothing has happened. So the situation is still the same. Thank you very much.
Thank you so much, Mr. Stau. Any reflection?
Thanks again. Thanks once again, Chair. Let me just say, Chair, I am quite happy to note that the Department of Home Affairs has noted in its response the submissions made from this end, submissions which suggest economic spin-offs for rolling out these one-stop border posts. Thanks a lot, Chair.
Thank you so much. Mr. Palazzi? Have you anything to say? Is Mr. Palazzi still part of us? 1, 2, gone. Thank you so much. Well, Mr. Malakate, you have heard the honorable members and also the presenters. What's your take?
Thank you, Honorable Chair, and thank you to honorable members for the questions. Chair, let me start with Honorable Noah in relation to whether or not following from today's meeting, whether or not there is a need for us to hold another public hearings, and this is a question that it would have been best answered by the Parliamentary Legal Services to assist the committee in this. But as far as I understand the processes, we following this meeting, there would be no need for the select committee to call for another public hearings. But then we can proceed with the deliberation. And I think Mr. Dixon can also assist in terms of the process. But the process, as I understand, is that at this point in time there would be no need to hold any other further public hearings or public engagement. Also to Honorable Noah that the department in developing both the policy on the establishment of the white paper and also the development of this bill before it was submitted to Parliament, there were very lengthy, dedicated consultations that we had, and in fact, the white paper was published for public comments. And I recall that some of the presenters today were also made representation or submitted written representation in as far as it relates to the development of the white paper. So even we're at the stage when we had developed the legislation as it is before the select committee, there were calls from the executive for public participation process. When the bill was tabled and was deliberated by the Portfolio Committee on Home Affairs, the Portfolio Committee also called for public participation, and there were submissions relating to this work. So there has been public participation processes relating to this, and we do because Honorable Noah, because we are just responding to a parliamentary process. You would recall that the select committee itself published a bill and calling for written submissions from interested persons and institutions to submit written comments to the select committee. So we don't have, as a department, we don't do separate consultations outside of the parliamentary process. So this is the process that we follow, and we do not do. So we did not have, and we are not allowed in terms of the principles and the the process and procedure to have other engagement with those who have submitted written representation outside of the parliamentary process. Chair, the issues that have been raised by Honorable Ferrick, those are issues, Chair, that are above my pay grade. I can only respond and indicate that I have taken note of the issues that Honorable Ferrick has raised, and I will make sure that it does get to the Office of the Director General en route to the Office of the Minister for them to be able to then come back and respond on those issues. Thank you, Chair.
Thank you so much. I now got Mr. Palazzi did indicate to me on the chat box that he had some hiccups on network, which we all understand. Now, Mr. Palazzi, are you in a position to talk to us? It looked like this challenge still persists. Thank you very much. If there is any other thing, you can write in the chat box and your comments, and also, of course, to the Secretariat as we are done. Honorable members, I'm suggesting that let the Secretary actually have our Secretary Gershwin to just make suggestion on the way forward, and then I'll then deal with the question of announcement and closure of the meeting, unless closure of the public hearing, sorry, so that we can then deal with other matter, the last matter, which is community consideration of the revised APP for 2026-2027, which is part of our agenda. Gash, any information on the way forward?
Thank you, Chairperson. Acting Chairperson, thank you, Nkosi. So in terms of the way forward, the department, in terms of our processes, we've now advertised, we've received written comments. We've reported on those comments. We've had oral presentations on those comments, and the department has responded in terms of their position, in terms of the recommendations that were made on those comments. The next stage, Chairperson, since we've only received 6 comments on this bill, and in terms of the NA, they've only also received 9 comments. We've gone over and above what the NA has already done in terms of public hearings, Chairperson. Then in terms of the next stage, we would propose moving straight to the deliberations, consideration and adoption stage of this bill, Chairperson. And I say this in the sense that in terms of our timelines going forward, in terms of Joint Rule 245, there is a deadline of September to conclude deliberations on the bill. If there are any proposed amendments, Chairperson, then that bill will still have to go back to the NA for the NA to decide on those proposed amendments in terms of Section 75 of the Constitution. So, Chair, just to conclude, I would say that in terms of our preparations, we are well advanced. We've covered everything in terms of public participation. And the next stage would be for the committee to deliberate on whether they accept the department's responses in terms of recommendations. Thank you.
Thank you so much. That is our committee secretary, our guest. And I think now that there is no further hand, can I then take this opportunity to really thank the Secretariat for organizing this meeting and for making sure that the people that has actually caused us to have this meeting, the people who are actually must have a say, are actually advised in advance, and they submitted their own submissions, and they further given an opportunity today to elaborate on these submissions, which were interrogated, and I'm pleased that there is emerging now a consensus and an understanding on both sides of the aims and objectives of this bill, which is accepted by all parties that are here. And I may indicate that as members, we've just heard today, as the Secretary correctly pointed out, we will have our own time again to deliberate on this. As political parties, we will therefore naturally consult our own principles. And then on the date to be announced by the chair in consultation with the Secretariat, we come back and deliberate and hopefully to approve the bill. But I must indicate that besides the bill, if then we can incorporate certain amendments, I want to assure the presenters that some of their submissions may find a way in the applicable legislation, rather regulations to implement. As we know, besides the policy framework of the department, then naturally the ministry is given powers to promulgate certain regulations, and I'm sure some, if not all, there are submissions needed to be considered there, as their public representatives will make sure that what they have actually made submitted to us are actually applied, as we have indicated from the department that there's nothing that is untoward as regards their submissions. And in respect of our oversight responsibility, we'll be able to make sure that the department continue to do what it needed to do. That being the case, honorable members, and we may conclude this this part and then deal with the next part. That is in respect of the revised APP for 2026-2027. I did notice the hand from the Secretariat as I was concluding this first part. If there's anything that I've omitted, please come in, Secretariat.
Apologies, Acting Chairperson. We do have the Parliamentary Legal Advisor, Mr. Moshakua, on the platform, Chairperson. I'm not sure if you want to ask the legal advisor if he has any comment, but he will
Oh,
be
yes.
part of the deliberations going forward, Chairperson. Thank you.
No, it will be important. Thank you so much. No. We can't just have our legal advisor part of the furniture and say nothing. Please say something.
Good afternoon, Honorable Chair. Good afternoon, honorable members and colleagues. I've been listening and following the proceedings. Unfortunately, I've got nothing to add. I have really considered what has been said. Thank you, Honorable Chair.
Oh, thank you so much. Our guests are free to log out or free to be part of us, it doesn't mind. But let us therefore consider then the last item of our agenda, which is the committee consideration of the revised APP for 2026-2027. Can you present this item, Secretary? Okay, I can see the Hotlo. Mashoka. Who is presenting? Cash? Sisters, please. Honorable members, perhaps, honorable members, there is a document of the Senate committee. Oh, yes. Now the secretary is coming. I was going to take over. Now, secretary.
Apologies, Chairperson. I had some technical difficulties. Let me just quickly share the document if I may. Thank you, Nkosi. I would actually prefer our content advisor to step in when if she feels comfortable just correcting me where I may go wrong. But let me continue, Chairperson, for expediency. Chairperson, so this is the 26-27 annual performance plan, which members was presented to members in I think it was April, if I'm speaking under correction, Chairperson. But it was adopted, Chairperson, and this is now just the process to formalize it. We just want to report, Chairperson, that we've accomplished quite a few of the term two's accomplishments, Chairperson, and then just looking forward to the term three. As we've said, Chairperson, there's the Department of Home Affairs, which we've now dealt with in this term on the public hearing. And then the next phase will be the consideration of the one-stop border post bill. And then, Chairperson, we've also included a briefing from the Department of Home Affairs on visa irregularities, which has come up in this year, Chairperson, particularly with our international sporting events. And then in terms of submission and further processing of the defense bills, they are currently following the supply chain management process, which we hope to conclude by next week, Chair, and then they'll be advertised until the 31st of July, which will then be in time for term three, where we can deliberate on those bills. And then the colloquium on the ERCP was proposed by members. We are still processing the internal arrangements, and we will report back on that again when we have more information on that, Chair. And then the IEC meeting did take place. So in terms of that, we are ahead with the IEC, but members can indicate if they need any additional time with them and submit it to the chairperson. And in terms of capacity building, Chair, we had a joint meeting with SC Social Services. The only problem with this meeting might be that the term is quite short. It's 4 weeks. We have 1 week for provincial week, and then we have another week for committee oversight week. So effectively, there's only 2 weeks left of August, which we will plan around and then inform the committee accordingly. And then, Chairperson, just the dialogue with the gangs, etc., organized crime and SAA in the deployment. And then we are meeting with the anti-corruption bodies, provincial briefings on illegal firearms, provincial briefings from SAPS and SANDF to assess the effectiveness of deployment of SANDF, and meeting with the DMV, DHS, and COCTA to understand the rollout of houses in all provinces with clear timelines. Chairperson, as I indicated, the term is quite short, so we will schedule our programming accordingly and then report back to the committee on what is feasible for term 3. And then in terms 4, Chairperson, we have the annual report meeting with the following departments and entities: Department of Justice, Correctional Services, and JICS, and dialogue with CSO on Chapter 9 and the function with the JCPS cluster, and then meeting with all departments implementing the integrated justice system. And then Chairperson meeting with Provincial Commissioner Western Cape, following up on escapes from police custody and gang strategy. And then the joint dialogue with PCA Home Affairs on borders and illegal immigration. And then we have also the stakeholders and departments on the implementation of the Domestic Violence Act, Chairperson. And then, yes, Chair, and then just continuing provincial dialogue with CPFs, neighborhoods, watch structures and SAPs, and CPFs, Civilian Secretariat for Police Services, and then meet with DIRCO on global developments and include DHA on intergovernmental cross-sectoral issues related to border management. And then in the last term, Chair, we have the meeting with SAPS on the outcomes of the Commission of Inquiry and change management strategies, meeting with the Minister DPWI, following up on the Free State Northwest infrastructure, symposium on the magistrates and the judiciary, meeting with SAPS on the implementation and effectiveness of the rural safety strategy, traditional policing, and the synergy of policing at national, provincial, and metro levels, and then meeting with the parole boards, and then we can complete all outstanding legislation during this period. This period is also the identified period for the study tour, considering that we have local government elections in November, and we'll take direction on that, Chairperson. Thank you. I submit.
Thank you very much. I can see the hand of Van der Berg.
Good afternoon, Honorable Acting Chairperson and Honorable members. Thank you, Gershwin, for taking the members through the document. Honorable Chair, just to say that, so that document really, I've compiled all the comments that the members made in the strategic planning session that we hosted in the Northwest Province. If anything I've left out, anything, members are welcome to forward those additions to us. As Gershwin indicated, the third term is going to be a short term, and we do have the defense bills before the committee. So in all likelihood, we would also be prioritizing legislation moving forward. But Honorable Chair, we would need to adopt the document so that we can forward it then to the Office of the House Chair. Thank you very much, Honorable Chair.
Thank you so much, Madam, and thank you so much, Gash, as well. Honorable members, the document was circulated to us, and we have just heard now it's been formally presented before us at this meeting. Can I ask for a mover for adoption?
Chairperson.
Yes, Honorable Noah.
My apology, I must confess, I haven't applied my mind so much on this document that was before us and look at it, but there are certain areas which at least they have been in my mind. Some of them presented here, some of the areas presented, the tricked that areas. One, Chair, I think the last time considering our oversight, I must say, Chair, that somehow it seems like we do consider and agree that it is important to give feedback to people that we engaged with. And Chair, that is what I'm raising now directly without being like I sound as though I'm representing a particular person. This relates to our oversight in Free State. You remember in Harrismith where you were in Fixback where you were chairing. And there's this individual chair that has been making follow-up on his submissions as to when are we going to be giving the response. And nothing is coming forth. And it seems like that we don't accommodate. If I looked well on what Gershon presented here, as I said, I haven't gone through it on my own thoroughly. But I just want to raise that concern, Chair, because, you know, when you, this person consistently continue to inquire from me about our coming back, and I've been able to, at least to calm him down that, you know, things are still going through the processes of Parliament. Sometimes, indeed, they take time. Now that the report has been tabled before the NCOP and has been adopted, how then do we actually, in a broader sense, accommodate feedback so that it shouldn't seem like we are just ticking the boxes? And then secondly, on the tabled program for future meetings, or before I come to the future meetings, Chair, we were not all of us in the meeting with the IEC, and my apology if I missed this one. Again, those of us who were not in that meeting, I'm not sure whether there was a report circulated out of that meeting so that we have an understanding. As I was on the ground, you know, some of the things you thought, if you were in that meeting, you could be having a better understanding in terms of the registration, the last registration. Hence, I had to ask for contacts of the provincial chairpersons because I did encounter some challenges on the ground. And then lastly, this one where I'm saying, for future meetings as suggested in the plan there, is it not possible, if it's not going to cost maybe too much work for the officials in totality, respectively in terms of their roles, that perhaps before we go and meet with the person, the structures, like I see the one that will be led by General Mukanazi, that we have the papers that relates to the meeting, and before we go and meet with the structures, then we have a meeting to engage with these papers so that we don't receive the documents on the eve, even if it's a week before the meeting, and then we go and meet with the structures before we consolidate the position of the committee. I don't know, I might be naive, but I consider it somehow that could be helpful, where we discuss first the documents as they will have been put together from the research, and then we engage with them, we get full understanding of the researched work, and we also engage with, so that when we go and engage with this department of structures, at least it's based on something that all of us will have discussed. But that will depend on the time. I know we have got heavy schedules. It might not be necessarily a physical meeting, but in similar platforms. But I guess it might be helpful. Thank you, Chair.
Yeah, thank you, Honorable Noah. Secretariat, can you just clarify if there's any? I'll come back after you.
Yes, thank you.
Yes.
Should I proceed, Honorable
Yes,
Chair?
yes.
Okay.
Yes.
Thank you, Honorable Chair. Thank you, Honorable Noe. Honorable Noe, I think you're raising quite a few issues related to methodology and how the committee operates. So in terms of the the Free State Oversight Report. The oversight reports, when once they are adopted by the NCOP, the recommendations are then sent through to the relevant departments, and the NCOP would then receive the feedback on those. So it's for us then, as the Secretariat, to just follow up with the NCOP to find out what they've received and then to filter that back to the committee, which we will do. But then also just to say, when we conducted our strategic planning session last year, we did say that when it comes to giving feedback to communities after the oversight, that we had agreed, when we had discussed the strategic plan, we discussed the methodology that the member responsible for representing the province would then be the one who would give that feedback. But I understand where Honourable Noe's concern is coming from. Certainly, we will follow up with the NCOP on those responses around the Free State recommendations and then submit to Honourable Noe. In respect of the IEC, Honourable Noe, I just wanted clarity, or at least just in terms of our future planning. Are you suggesting that we should set up a follow-up meeting with the IEC independently as our committee? If so, the only concern would be that they are busy with the local government elections preparations, and from what we've experienced, it's been really difficult to meet with them. That's why we had the joint meeting. But perhaps through you, Honourable Chair, if Honourable Noe can just clarify that with us. And then Honourable Noe will take it into consideration, the issue of prior briefings to intense committee meetings, and we will discuss that within the Secretariat, and we take the point. Thank you very much for the recommendation. Thank you, Honourable Chairperson.
Yeah, no, thank you, Madam. Thank you so much. And thank you, Honorable Noe. I think in support of what Madam has already indicated, Honorable Noe, just slight suggestion to you, Madam, that this is not no Honorable Noe's business. It's our business as a collective, because we did make an undertaking. So obvious in respect of a follow-up in Harrisburg and Philsberg, and I would suggest then that let it be escalated to the secretary, to the chair, and so with a view, then we can actually assist the administration to make sure that we do deliver on our promises of reporting back, and how we should do that will be guided by the Presidium. And secondly, on the question of the IEC, you are quite correct. There was a joint meeting, all what Honorable Noah is asking, which is a good point that is raising. It's just that key decision be circulated. I don't think that there will be any time for us to have any interaction with them as we intended. Honorable members, we wanted to visit IEC, situation could not, and then naturally we had this joint meeting, and it held in the manner in which it was held, and of course we all know that 4th of November is next week, and therefore we don't have luxury of time. Hence, I think Honorable Noah's proposal that let there be a report on key decision that is circulated. I think the Secretariat we can be able to do that, to circulate to all the members. And thank you very much for agreeing with the third point of Honorable Noah, that indeed there is a necessity for us to plan and to exchange views before we go to any committee meeting. It is really very productive. It has been proven in one or two incidents before. That being the case, we have clarified. Can we have a formal mover? And can I say, can I get somebody to formally move then for adoption of these select committees, APPs for 2026-2027 annual performance plan, please?
Chair?
Yes.
While I'm moving, just to share with you
give you a feedback alongside of the IEC. You captured well my input. Just one slight feedback around that. As I was visiting the stations, what made me ultimately to call the provincial chair. You will reckon as people visit, observers or party agents or security guys, there is a register to sign. However, it doesn't accommodate public representatives to also can come and observe and look at what is going on. I had to sign on the political organization agents and observers. So I made this point to the chairperson, the provincial chair, and he also considered it to be a very important point that there should be an accommodation of public representatives as they visit the stations. I'm just putting it forward that as we engage with IEC, maybe this could be one feedback to them from the committee. And then the other one, then he responded also by saying, probably there might be a need for notices to them, and then so that they can be made aware in areas where there are public representatives like us as a committee, probably that we might be playing oversight during those times, because we have got that responsibility so that we can give feedback out of what they will have presented to us, and then we go and follow up whether indeed things are happening as they have presented, so that that interaction continues based on feedback on how they performed and what we found on the ground. So there should be a way of ensuring that during those times, committee members or public representatives, there must be a way of communicating our presence and during the execution of IEC programs. Thank you very much, Chairperson. I therefore move.
Thank you very much. Any seconder? Members, any seconder? Cash, are the members still logged in or out?
Acting Chair, the members are still online.
Okay. All right. Honorable members, Honorable Palate, you can leave. I see you are writing something. You are still here. I did release all you. It's fine. Thank you so much. Honorable members, any seconder? Let me just call to make sure that people have not left. Kim.
No, Chair, members are still here.
Honorable Kharik? All right. Oh, okay. Can you join in? I can't hear you. Can you join in second the approval of APPs? Honorable Kharik? Honorable Kharik?
Chairperson, sorry, my
Oh,
apologies.
yeah. He said, I'm tempting to speak, Honorable Godsell, I can see. I'm tempted to speak to second, okay. Yes, Honorable Kharik?
What is the request now, Chair? I was breaking up.
Okay, the APPs, our APPs for 2026, 2027, the Honorable Noah has moved for adoption, and I was looking for a seconder.
Yeah, let us second. It's fine.
Thank
Thanks.
you very much. And I also notice the support from Honorable Godsell. Colleagues, thank you so much. Then the APPs, because even Kim Mutubi was actually on my line indicating that she would do the same. Then can I take it, there being no opposition, that we are now in agreement to have this 2026, 2027 APP. Thank you, Secretariat. Thank you very much for the wonderful work. Continue to do us proud, and we hope we're not going to disappoint you as well, because it is good to work for the people that really value your services, and I hope you value our services as well as we do our work to represent our people. That being the case, colleagues, what was presented before me as the agenda is coming to an end. Thank you for the time.
Sorry, Chair.
Yes.
Sorry to bother you so much.
Yeah.
I might have missed this one maybe during the secretary when he was making a summary of the outcome of the previous item. Aren't we supposed to decide going forward about the public, whether we proceed with the public hearings or not, or that will be done when we come back from the recess, or what is the position?
Yes, no, the position is that we will, so far, our prima facie view is that there's no need, but we're going to make sure that the legal services of Parliament does reflect on that. Hence, we agreed that we'll meet in September again as a committee to receive a comprehensive report for formal adoption of the bill.
Thank you.
Thank you so much. Colleagues, that being the case, thank you very much, colleagues, for really wonderful. I think you have saved yourself time. It's now towards 12:30. I think we did have a very productive meeting. Keep it up, colleagues, and we have got work to do, and use the remaining minutes to do what you need to do for our people on the ground. And congratulations to you. Thank you, Secretariat, again. And the meeting is adjourned. God bless you all.
Thank you, Honorable Chair.